All right, just moments ago on Tuesday, February 10th, 2026, the silence finally broke, and the timing is not accidental. As Ivanka hits a hard procedural deadline, Trump steps back into the public arena, and what initially looked like a private family fracture suddenly transforms into a legal problem with teeth. Because in everyday life, silence can simply mean hesitation, but in court, silence can mean something else entirely. In the docket world, silence can be read as non-compliance. And once non-compliance is on the table, judges stop waiting and start acting. Here's how fast this moved. At 8:04 a.m. Eastern, a clerk's notice appears on the fictional docket of the United States District Court for the Eastern District of Manhattan. It schedules an emergency compliance status conference for 1:30 p.m. that very same day. No buffer, no runway. At 8:11 a.m., a sealed attachment is partially unsealed, just enough for the exhibit index to become visible. At 8:18 a.m., the defense submits a short letter requesting additional time. 8 minutes later, at 8:26 a.m., the judge denies that request in a single paragraph minute order and keeps the emergency conference firmly on the calendar. And then, at 8:33 a.m., Trump posts his first direct public statement in nearly 48 hours. That post is what everyone will clip, but it is not the story. The real story is what the court did before he posted. Because when the court moves first, your statement is no longer the lead, it's the response. Here's the compressed timeline that actually matters, because this sequence is the spine of the entire episode. On Friday, the court issues a compliance directive with a firm deadline. On Saturday, the defense signals that it may not be able to meet that deadline as written. On Sunday, internal family communications fracture and no unified public or legal posture emerges. Monday night, the moving party files a notice of non-compliance and requests immediate enforcement. And Tuesday morning, the judge schedules an emergency conference and orders personal appearances. 3 days. That's all it took for this to go from manageable to urgent. And the pressure point in this fictional packet is simple. Ivanka is facing a court-imposed deadline tied to surrender, production, or sworn certification. Pick your procedural flavor. The court's framing is the same either way. You were ordered, you were warned, you were given time, and now the clock has expired. That's why the family rift suddenly matters. In high-profile cases, legal strategy depends on coordinated behavior. Messaging, timing, posture, everything has to align. When families cannot coordinate publicly, they often cannot coordinate procedurally either. And judges sense that breakdown faster than the internet ever could. Quick context in one breath so no one gets lost. In this dramatized scenario, Ivanka is a defendant in a high-visibility matter, blending alleged financial conduct with strict procedural obligations. Trump is both a political force and the family figure whose public posture shapes the ecosystem around the case. And the court, again fictional, has reached the point where it wants to know whether compliance is real or merely performative. Now the hook everyone sees is Trump breaks his silence. And here's why that hook works. The audience assumes his silence was strategic, but the docket suggests the silence reflected uncertainty. And in this story, uncertainty is what triggered legal acceleration. Monday night, the moving party, think prosecutors, a task force, or an enforcement unit in this fiction, files a short notice. It attaches a compliance log and alleges that the defense missed a surrender or production deadline without timely seeking relief. That filing alone triggers an emergency posture. The judge's first priority becomes preventing the process from slipping out of the court's control. Competitor scripts always walk viewers through the packet, so let's do that. Document 1 is the notice of non-compliance. It lays out the order, the deadline, and the failure in checklist form. Order issued on date A. Deadline set for date B. Reminders sent on date C. No completion received by date D. No drama, just sequence. Document 2 is the request for immediate enforcement, where the moving party asks the court to act now. Issue a bench directive, modify conditions, compel sworn certification, order marshal-level assistance, or schedule a same-day conference. Document 3 is the exhibit index, service confirmations, communication logs, travel summaries, device custody forms, a short declaration from a custodian. It tells you exactly what kind of leverage they're relying on. And here's where it gets human and messy. The packet references a family witness posture issue. It doesn't accuse anyone of a crime. It doesn't allege obstruction. But it implies that a close family member was approached to help soften consequences and either declined or offered testimony that wasn't helpful. That distance matters, not emotionally, but legally. Courts don't care about family drama. They care about whether the people closest to a defendant are signaling reliability or risk. In this fictional script, the moving party points to that distance to argue flight risk, non-compliance risk, or credibility risk. And that's where everything accelerates. Now comes the part competitor scripts love, the unexpected turn. What nobody saw coming wasn't the existence of a deadline. It was that the defense apparently assumed it could be managed quietly, while the moving party treated it as a hard line. And the judge sided with the hard line by moving fast, because the judge's minute order Tuesday morning uses the language judges use when they are done negotiating. Immediate clarification required. Parties shall appear. Failure to comply may result in enforcement remedies. That's a tone shift. And that tone shift is why Trump breaks his silence. At 8:33 a.m., he goes on offense. He calls the process unfair. He frames the pressure as political. He insists his daughter will be vindicated, and he attacks the actors inside the system. But courts don't respond to offense. They respond to compliance. And now his statement creates a second problem. It raises the temperature hours before an emergency conference, making it harder for the judge to keep the proceeding narrow and procedural. That's why lawyers dread public posts. Judges want to decide whether a hearing is about a specific remedy or a broader escalation. The louder the public conflict, the easier it becomes to justify tightening control in the name of institutional integrity. The defense's two-page letter Tuesday morning argues that compliance is underway, that timing is being weaponized, and that enforcement would be disproportionate. The moving party counters that informal flexibility is not a legal mechanism and that delays were created by internal indecision. In plain terms, the rift delayed the plan, the delay missed the deadline, and the missed deadline triggered the judge. That's family rift turns legal overnight in one sentence. Patterns matter in this genre, so here they are. Pattern 1, weekend escalation. Filings on Friday night or Sunday morning are designed to force a Monday reaction. Pattern 2, compressed sequencing. Same-day conferences signal perceived risk. Pattern 3, dual messaging. Public offense paired with legal caution equals scrambling. Pattern 4, certifications. Judges love sworn certifications because they convert fuzzy narratives into accountability. If you can't certify, you correct or you face consequences. So what's the court signaling next? A shift from voluntary compliance assumed to compliance verified. That can mean sworn surrender confirmations, production inventories, passport surrender, monitoring conditions, or marshal assistance. The specific tool isn't the point. The posture is. The court no longer assumes. It checks. To be fair, defenses have arguments. Deadlines can be tight. Public figures face pressure. Enforcement units sometimes overreach. Courts sometimes rein them in. All of that can be true. But once an order exists, the deadline is real. Extensions require motions. If you don't file one, you don't get one. Judges treat that as basic procedure. At the emergency conference, the judge opens tight. Was the deadline met? Yes or no? Context is cut off. The defense concedes partial noncompliance and argues good faith. The moving party argues that partial noncompliance is still noncompliance. The judge responds by doing what judges do when they sense drift. Sworn certification within 24 hours, a narrow list of actions by close of business, a follow-up hearing scheduled with a warning. If the court is not satisfied, enforcement will expand. That's not a ruling on guilt, it's a ruling on control. Experts would tell you the same thing. Treat deadlines as negotiable and enforcement follows. Public statements lock narratives in place. Once someone is labeled non-compliant, the system becomes mechanical. Courts protect process aggressively because process is legitimacy. Zoom out, and this matters beyond the family. When courts tighten compliance posture for the powerful, the baseline shifts for everyone. Prosecutors cite it. Judges become stricter. Informal flexibility disappears. That's how precedent works in practice, not just opinions. The most immediate risk, though, is simple. if the court believes family dynamics are undermining compliance, it removes discretion from the family and places it in enforcement. That's what rift turns legal overnight really means. As of right now, in this fictional scenario, Ivanka has hit a deadline. The moving party alleges non-compliance. Trump has broken silence. The court has scheduled emergency proceedings and ordered sworn certifications. And what began as internal distance has become a procedural factor the judge is actively weighing. This didn't change slowly. It changed because of a deadline. And deadlines are the hidden engine of these stories.